Hello, my dear students. Today we'll talk about the Industrial Employment Standing Orders Act 1946. In this act, today we'll talk about the concept and nature of the act. Concept and the nature of standing orders. Industrial Employment Standing Orders Act 1946. Clarity of obligations and privileges play a major role in cordial relations in the industry for the work satisfaction and performance also. The same is true in the context of employment conditions in industrial settings also. The Labor Investigation Committee in its report had observed that an industrial worker has the right to know the terms and conditions under which he is employed and the rules of discipline which he is expected to follow. So the Labor Investigation Committee had observed this thing that industrial workers, those who are working in any industrial establishment, they have this right to know what are the terms and conditions of their employment under which they are working and the rules of the discipline which he is expected to follow. So Labor Investigation Committee had observed this thing. And broadly speaking, in Indian industry, the rules of service are not definitely set out and likely all unwritten laws where they exist, they have been very elastic to suit the convenience of the employers. Means usually employers try to frame the rules as per their convenience, where the employer can feel comfortable or where the employers feel comfortable, and they try to go for a dominating position. Accordingly, they frame the rules for the industrial establishments. No doubt, several large-scale industrial establishments have adopted standing orders and rules to govern the day-to-day relations between the employers and workers, but such standing orders or rules are clearly one-sided. Yes, the several large industrial establishments have adopted these standing orders and rules to govern day-to-day relations between the employers and the workers. But most of the times you will find that these standing orders or the rules are clearly one-sided because employer frames those rules and regulations as per their convenience or as per their uh, area of the zone of comfort, because they do not want to come out from that comfort share. So accordingly, they frame these rules and regulations. Neither workers nor the workers of the organizations nor the government are generally consulted before these orders are drawn up, and more often than not, they have given the employers the upper hand in respect of all disputable points. So, in this way, we can say that most of the times we will find that employers are usually having the dominating position. It was to overcome from these evils that the industrial establishments or the Industrial Employment Standing Orders Act 1946 was passed to require the employers in industrial establishment to define with sufficient precision the conditions of employment under them and to make these said conditions known to workmen employed by them. So these employment standing orders was just to overcome from all these evils, because earlier what was happening prior to this enactment, that employers, they were trying to dominate the workers. They were just trying to dictate their terms and conditions on the workers, on the employers. And with the help of this enactment, certain rules were made so that the employer will not be able to dominate, to dictate the terms. Before this act, there was no law to prevent the employer from having different contracts of employment with workmen that led to confusion and discriminatory treatment. Because see, once this act was enacted, prior to this act, there was no provisions, and employer was in a position to dominate the show. So employees, though, were dissatisfied, but they were just not having any platform to register their grievances. The tripartite labor conference pleaded for defining the conditions of employment so as to create harmonious relations between employer and workman. In this labor conference, it was pleaded that conditions of employment are very much important and essential to create harmonious relations between employer and workmen in an establishment. And before this act, the victimization and unfair labor practices were quite frequent, and the industrial workers were not having any right to know the terms and conditions and rules of discipline of his employment. The workers, they were unaware about the terms and conditions of the employment. They were just not knowing that what are the terms of their employment. They were victimized with unfair labor practices, and these unfair labor practices were quite frequent in most of the industries. And industrial workers, they were just not having any right to know the terms and conditions and rules of discipline of his employment. So in that way, my dear students, we can say that prior to this enactment, there were no such provisions to safeguard the rights of the workers in terms of the terms of conditions of the employments. And with the help of this enactment, now the workers can easily check whether the treatment or the terms and conditions they are having at the workplace is up to the mark or not, or just the the employer of the workers, these employers are following the rules and regulations given under the act or not. So basically we can say that the purpose of this enactment was to just overcome from the evils, and with the help of this enactment, sufficient provisions, the conditions of the employment under them, and to make the said conditions known to the workmen employed by them. So the important aspect of this act is that the rules, regulations, one aspect, and the other one is that now workmen or will be aware about these terms and conditions with the help of this act. So this is the concept and nature of the standing orders under this Industrial Employment Standing Orders Act 1946. So my dear students, this is all for today. And in our next lecture, we'll take another topic related to the Industrial Employment Standing Orders Act. I wish that this lecture would be definitely help you. Thank you so much. Have a good day.